Great to see you, Mark. Jonathan, great to be with you.
Mark, good to be with you. So what great nuggets from the world of litigation do you have for us today? Something
Well,
interesting, I'm sure.
Wanted to talk about a employment case recently decided. There's a ton of employment cases. A lot of them have been decided recently relating to the misclassification of employees as independent contractors and the Wage Act. It's a fertile ground. You pick up the newspaper almost every day, you see some kind of case being brought in this area and in a whole variety of industries. But you know, the restaurant industry in particular with the Wage Act requirements under the tip law and just it's almost impossible to have independent contractors under current Massachusetts law. But in this case, a plaintiff filed suit against a company that provides delivery service. So the delivery drivers claim that they were misclassified as independent contractors under Massachusetts law.
So the plaintiff in this case was a delivery driver?
Yes,
Okay.
So they sued this Texas company called Dynamex. And the case was litigated in the Superior Court in Massachusetts for 2 years. And then after 2 years, the defendant company sought to have the case dismissed on the basis of there was an agreement they produced between the plaintiff and the defendant under which Texas law, not Massachusetts law, would control the relationship, and disputes had to be resolved in Texas, not Massachusetts. Well, the problem is that they litigated the case for 2 years in Massachusetts. The defendants filed a lengthy answer and 28 affirmative defenses, and they never raised the issue of Texas law. And the plaintiff never produced the agreement, and neither did the defendant for 2 full years. Kind of a
Interesting
bizarre,
oversight.
a bizarre thing. So it must have been sitting in somebody's bottom drawer someplace.
Mysteriously appeared towards the end of the case.
Yeah, you know, maybe
Could
the
be.
defendant didn't like how the case was going.
That could be,
So-
I was going to say, Mark, that could be grounds for potential legal malpractice.